Okay, let's dive in. We're tackling something that sounds simple, but is actually a minefield in contract law conditions. The real challenge we're exploring today is how you navigate deals where everything, your whole obligation to perform or pay, just hangs on some uncertain future event actually happening. Think of them as triggers or maybe limiters. Condition is basically an event, right? Something uncertain that has to happen or maybe not happen before someone actually has to perform their side of the bargain. Professor Feriel had those great examples, didn't he? Like, you only get dessert if you finish your Brussels sprouts. Eating the sprouts, that was the condition. It unlocked the dessert duty.
That's a perfect way to put it. And our mission today, really, is to get a handle on how conditions shift risk so dramatically. Because look, when a condition fails, it's like the nuclear option, legally speaking. It can wipe out a duty completely. So to really get this, we need a clear analytical path. First step, tell the difference between a condition and just a regular promise. Second, classify them. Are they express, spelled out, or constructive, implied by law? And finally, figure out the standard of performance. Sometimes it's brutally strict, other times there's more leeway. It's all about learning that step-by-step, element-focused analysis.
All right, let's start with a really scary part, failure of an express condition. What are the general consequences when that specific thing just doesn't happen?
They're immediate and often, yeah, brutal. If an express condition doesn't occur, the duty that was hanging on it's just discharged. Poof, gone entirely. And critically, unless the party who was supposed to make the condition happen also promised it would happen, what we call a promissory condition, then its failure doesn't even give the other side a right to sue for damages. It just kills their obligation.
Okay, that is harsh. Let's look at a case that really hammers this home, where the court stuck to the letter of the law. Inman v. Clyde Hall Drilling Co. So first things first, what are the legally dispositive facts here?
Right. So Inman was an employee, and he got fired. His employment contract had this very specific procedure for grievances. It said, point blank, you had to give formal written notice of any claim within 30 days of whatever happened. But Inman, well, he didn't do that. Instead, he just went ahead and filed a lawsuit against the company, although he did file it within that 30-day window.
Okay, so he gave notice through the lawsuit, just not the way the contract said. And what was the core legal issue the court had to wrestle with?
The key question was, did filing that lawsuit count? Did it satisfy the express condition requiring formal written notice as part of that whole mandatory procedure laid out in the contract?
And to get to their answer, what specific legal rule did the court apply? Can you state the rule and break down its testable elements?
Yeah, they basically brought down the hammer with the rule of strict performance for express conditions. The idea is, if a duty depends on an express condition, you have to meet that condition exactly. And here, the rule, based on the contract, had two distinct elements you had to follow in sequence. First, give formal written notice within 30 days. Second, you had to observe a 6-month waiting period before you could actually file a lawsuit.
Okay, strict performance, two elements. Let's walk through the court's elemental analysis. How did they apply that first element, the formal written notice, within 30 days?
Well, this is where it gets interesting. Even though the company technically got notice from the lawsuit within the 30 days, the court said, nope, that doesn't count. Their reasoning was that the formal written notice step was meant to be separate, a preliminary thing to maybe allow for internal resolution. By jumping straight to the lawsuit, which also broke the second element, the waiting period, Inman basically skipped the required first step as the contract intended it.
Right, he short-circuited the process. Okay, understood. Now, what about that second element, the mandatory 6-month waiting period before filing suit?
That one was pretty clear-cut. He obviously violated it by filing the suit immediately. The contract explicitly required waiting 6 months, likely to encourage talks. And because it was an express condition, the court felt it had zero wiggle room. They couldn't just ignore that part of the deal about the required timing. Strict compliance meant strict compliance.
So after dissecting both elements, what was the court's final conclusion?
The condition failed. Because Inman didn't follow the exact procedure, the express condition wasn't met, so his lawsuit was dismissed. The employer's duty to even face the claim about the firing, totally discharged, without the court even looking at why he was fired. Procedural foot fault, game over. #2, the strictness of express conditions versus substantial performance.
Wow. Okay, that case really shows the unforgiving nature of express conditions. But what about situations where someone almost gets it right? You know, the idea of substantial performance that sometimes saves people in breach of promise cases. Does that help at all with conditions?
Ah, good question. But for express conditions, the answer is a hard no. Substantial performance is a doctrine that courts apply to constructive conditions, the ones the court implies, or to breaches of promises. Express conditions, the ones written right into the contract. They demand literal performance, strict compliance. There's really no room for close enough.
Okay, no, close enough. Let's test that rigidity again with Oppenheimer and Go v. Oppenheim, Apple, Dixon and Co. This sounds like a big commercial deal gone wrong.
Yeah.
What are the key facts?
Yeah, this was a sublease deal between two companies. The party subletting the space, Oppenheimer, had a critical job. They needed to get the main building owner's written consent for some planned alterations to the property. And crucially, they had to deliver this written consent to the subtenant, Oppenheim, by a very specific deadline. What happened was Oppenheimer told Oppenheim orally, hey, we got the approval, right on time. But the actual written document, that showed up 23 days late.
23 days late on paperwork and a big deal. Seems minor, maybe. So what was the core legal issue here?
The issue was whether giving the oral notice on time and then the written notice just, 3 weeks late, did that count as substantial performance of the express condition requiring timely written consent?
Did almost count. What rule of law did the court use here, and what were its elements?
They went straight to the restatement of contracts rule, which draws a very sharp line. It says, express conditions must be literally performed, period. In contrast, constructive conditions only require substantial compliance. So for this specific contract, the express condition had two absolutely literal elements that needed to be met. First, the consent had to be written consent, not oral, and second, it required delivery by the specific deadline, not later.
Okay, literal performance, two elements again. Let's do the elemental analysis. How did the court apply that first element, the need for written consent?
They were very clear. The contract didn't just say consent, it specified written consent. Why? Probably to avoid any arguments later about who said what, especially in a complex deal. So the court reasoned, even though oral notice was given on time, it simply wasn't what the condition demanded. It failed the literal requirement of being a written document. Element 1 failed.
Okay, so the oral notice didn't cut it, but they did get the written consent eventually, just late. What about the second element, delivery by the specific deadline?
Right. It arrived 23 days late. And because the court had already classified this as an express condition, they said, and I'm quoting loosely here, there's no mitigating standard of materiality or substantiality that applies. It didn't matter if the delay was minor or caused no harm. The deadline was part of the express condition, and it wasn't met. Literal compliance was required, and late is late. Element 2 failed.
Man, zero flexibility there. So what was the court's final conclusion, and why such a hard line?
Predictably, the condition failed, and the consequence. The subtenant, Oppenheim, their duty under the sublease was completely discharged. They could walk away. The court's reasoning was basically about respecting the parties' bargain. They specifically negotiated for written proof by a set date, likely to manage risk and timing precisely. To ignore that, the court felt, would be rewriting the contract and undermining the parties' clear intent.
Okay, Chink, given how incredibly harsh the outcome can be if something is an express condition, how do courts handle situations where the contract language is, well, fuzzy, not totally clear if it's a condition or just a promise?
Now we get to the counterbalance. This is where courts often show some mercy, guided by a strong policy against forfeiture. Forfeiture means one party loses all their rights under the contract due to the condition failing. So, the default rule, the strong preference, is that if language is ambiguous, courts will construe it as a promise rather than a condition. Why? Because breaching a promise usually just leads to damages, which is seen as less harsh than the complete loss of rights from a failed condition.
That makes sense, trying to avoid that all-or-nothing outcome.
But you mentioned something earlier, the promissory condition. That sounds like it combines the worst of both worlds. Can you quickly explain that?
Exactly. A promissory condition is a hybrid. It's where a party promises that a certain event will happen, and that event is also designated as a condition to the other party's duty. So if the event doesn't happen, the person who made the promise is in double trouble. First, the condition fails, so they lose their right to the other party's performance. Second, they breach their promise to make the event happen, so they can be sued for damages. It's a real double whammy. Okay, definitely something to watch out for in drafting. Let's see the preference for promise rule in action. How about Rohauer v. Little? What were the essential facts in that case?
Right. This was about a land sale. The agreement said the seller needed to provide the buyer with either an abstract of title or a title insurance commitment. The specific language was that this document shall be furnished to the purchaser on or before July 10th, 1981. Well, the seller missed that deadline. The buyer immediately said, deal's off. claiming that meeting the deadline was an express condition to their duty to buy the land.
Okay. Shall be furnished by July 10th. Seems pretty direct. What was the core legal issue for the court?
The issue was, did that phrase, shall be furnished on or before July 10th, create a strict express condition? If yes, the buyer walks away clean. Or was it merely a promise by the seller to provide the document by that date, meaning the seller might still have substantially performed, even if late?
How did the court decide? What rule of law did they apply, and what were the elements they looked at in the language?
They applied that rule of construction we just talked about, the preference for finding a promise to avoid forfeiture when the language is ambiguous. They looked at two key things in the contract language as elements of interpretation. First, the lack of unambiguous conditional language, did it use the magic words? And second, the use of directive language, specifically the word shall.
Okay. Element 1. Lack of unambiguous conditional language. How did the court analyze that?
They noted that the contract didn't use classic conditional phrases like on the condition that, or if, or provided that, or subject to, the kind of crystal clear language you often see, especially in things like insurance policies where conditions are common. Because that explicit conditional language was missing, the court found ambiguity, and that ambiguity weighed against finding an express condition given the harsh consequence of forfeiture.
Right. No magic words. Understood. Now, what about the second element, the use of directive language, that phrase, shall be furnished?
The court pointed out that shall typically indicates a promise, a duty, a commitment to do something. It's language of obligation. Since the phrase created a duty for the seller but didn't explicitly and unmistakably tie the buyer's duty to the timely performance of that promise, the court chose the interpretation that avoided forfeiture. They read shall as creating a promise with a deadline.
So, putting those two elements together, what was the court's final conclusion?
They concluded that the clause was a promise, not an express condition. This was a big deal for the seller. It meant they hadn't automatically lost the deal. Instead of the buyer being immediately discharged, the seller got the chance to argue that, even though they were late, they had substantially performed their promise, and the delay wasn't a material breach serious enough to let the buyer walk away.
That really shows how policy avoiding forfeiture can steer the interpretation. Let's talk about another area where policy is huge. Those pay-when-paid clauses you see all the time in construction contracts.
Oh yeah, pay when paid is a classic example. Courts, like in the Peacock construction case, are very aware of the business reality here. You've got a general contractor hiring subcontractors. Typically, the small subcontractor doesn't have the resources, nor do they intend, to take on the huge risk that the owner might not pay the general contractor. They're usually just relying on the general contractor's credit. So unless the contract uses incredibly clear, unambiguous language to shift that specific risk, think words like payment to the subcontractor is subject to the express condition precedent that the general contractor first receives payment from the owner, or payment only if paid by owner. Courts usually won't interpret a simple pay when paid clause as a condition. Instead, they'll typically read pay when paid as just setting a reasonable time for the general contractor to pay the subcontractor, a promise, not as a condition that excuses the GC from paying altogether if the owner defaults. You need explicit risk-shifting language.
Makes sense. Protecting the little guy unless they clearly signed up for the bigger risk.
Okay, let's shift gears to something more subjective. Conditions that require someone's satisfaction or approval. Let's use a hypothetical. Imagine you hire a photographer for your wedding, and the contract says you'll pay only if you are satisfied with the photos. What standard does the law apply to your satisfaction?
Right. These satisfaction clauses generally fall into two categories, depending on what the satisfaction is about. Category 1 involves aesthetics, personal taste, or fancy. Things like wedding photos, a portrait painting, maybe tailoring a custom suit. For these, the standard is usually subjective. The person whose satisfaction is required only needs to be genuinely and honestly dissatisfied. They have to act in good faith, but their personal taste rules. Category 2 involves functional utility, operative fitness, or commercial quality. Think, does this machine work correctly? Is this roof structurally sound? Does this software meet the agreed specs? For these, the standard is typically objective. Would a reasonable person in the same position be satisfied? Your personal quirks don't matter as much. Okay, subjective for art, objective for function. But that subjective standard seems risky. What if Mike restores Cheryl's valuable antique chair? Contract says, payment conditional on Cheryl's satisfaction. She gets the chair back, it looks amazing, but she says she's dissatisfied just to avoid paying, even though she keeps the chair. What prevents that kind of game playing?
That's the exact scenario where courts get very suspicious. It screams potential forfeiture for Mike, he did the work, and unjust enrichment for Cheryl. She keeps the improved chair for free. When the party claiming dissatisfaction keeps the benefit of the performance, courts really scrutinize their claim of subjective dissatisfaction. They might be more inclined to impose an objective reasonableness standard, even if it looks like a taste issue, demanding that Cheryl's dissatisfaction be reasonable under the circumstances. Or, even if they find the subjective condition technically failed, she is genuinely unhappy, even if unreasonably so, they might still allow Mike to recover in restitution the value of the benefit conferred on Cheryl to prevent her from being unjustly enriched by keeping the restored chair without paying anything.
We spent a lot of time on express conditions, the ones spelled out. But you also mentioned constructive conditions, the ones courts sort of read into the contract when it's silent. Why do courts do that? What's the purpose?
Constructive conditions are basically judicial gap fillers, tools to ensure fairness and make contracts work sensibly, especially bilateral contracts where both sides have promises. Courts impose them to establish the proper order of performance when the parties didn't specify it. They ensure that, generally, one party doesn't have to perform their promise unless the other party is also ready and able to perform theirs. Think of it as ensuring the performances are treated as dependent on each other. Often this results in concurrent conditions, where duties are due at the same time.
Right, it seems obvious now that promises should be linked, but that wasn't always the thinking, was it? We need to look at the landmark case, Kingston v. Preston, to see how this idea of dependent promises really took hold. What are the crucial facts from that old case?
Yeah, this goes way back to 18th century England. You had a silk merchant, Preston, who agreed to sell his business to his apprentice, Kingston. It was basically a sale on credit. As part of the deal, Kingston promised to provide Preston with good and sufficient security, essentially collateral for the debt he would owe for the business. But Kingston failed to come up with the security. Nevertheless, he turned around and sued Preston for not transferring the business to him.
So the apprentice didn't provide the promised security, but still demanded the business. Okay. And what was the core legal issue for the court, led by the famous Lord Mansfield?
The big question was Kingston's promise to provide security completely independent from Preston's promise to transfer the business? If independent, Preston would have to hand over the business even without security and just hope to get paid later, or sue Kingston for damages. Or was Kingston providing the security a condition precedent, something that had to happen before Preston had any duty to transfer the business?
How did Lord Mansfield resolve this? What groundbreaking rule did he apply, and what elements guided his thinking?
Mansfield essentially invented the modern doctrine of constructive conditions. He rejected the old view of independent promises. His rule, basically, is that in a bilateral contract, the promises made by each party are presumed to be dependent on each other unless the contract clearly states otherwise. This means that the substantial performance of one party's promise acts as a constructive condition to the other party's duty to perform. The elements he looked at were really about fairness and commercial reality. First, the nature of the transaction itself, did it logically require security first? And second, the goal of prevention of injustice, what would happen if the promises weren't linked?
Okay, let's break that down. How did the court analyze the first element, the nature of the transaction?
Mansfield looked at it practically. Preston was selling his entire business on credit. The whole point of demanding security was to protect himself from the risk of Kingston not paying. It just made commercial sense that the security promise had to be fulfilled before Preston handed over his valuable assets. The security needed to come first, or at least simultaneously.
That seems logical. Now, what about the second element, prevention of injustice? How did that play into the decision?
This was really the clincher. Mansfield found that forcing Preston to transfer his business without getting the promised security first would be, in his words, the greatest injustice. It would leave Preston completely exposed, having given up his business on unsecured credit to someone who had already failed to provide the security. That strong policy concern, avoiding such an unfair and commercially unreasonable result, drove the court to imply or construct a condition.
And so, after considering the transaction's nature and the potential injustice, what was the court's final conclusion?
The conclusion was that Kingston's promise to provide security was not independent. It was treated as a constructive condition precedent to Preston's duty to transfer the business. Since Kingston failed to perform this condition, he didn't provide the security, Preston's duty to transfer the business was completely excused. This case fundamentally changed contract law, establishing the interdependence of mutual promises. #Tag6 Exam Framework Synthesis.
This has been incredibly thorough, really drilling down into that element-by-element analysis. So let's synthesize. For someone listening, maybe prepping for an exam, or just needing to analyze a contract clause in a meeting, what's the actionable step-by-step diagnostic checklist they should run through?
Okay, yeah, let's boil it down to a practical framework. When you encounter a contract term that might affect a performance duty, you need to ask these four questions, basically in this order. One, is it a condition or a promise? First, look for those explicit conditional words. If, unless, provided that, subject to, on condition that. If you see those, it's likely an express condition. If the language is ambiguous, remember the strong legal preference. Construe it as a promise to avoid forfeiture. Two, is it express or constructive? If it's clearly spelled out in the contract text, it's express. If it's not explicitly stated, but the court implies it based on the sequence of performance, fairness, or the nature of the deal, like in Kingston, then it's constructive. Three, what standard of performance is required? This depends entirely on the answer to question two. If it's an express condition, the standard is literal performance, no substantial compliance allowed, in Men's Oppenheimer. If it's constructive, the standard is usually substantial performance. Minor deviations generally won't discharge the other party's duty. Four, is it a satisfaction clause? If performance is conditional on someone's satisfaction, you need to figure out the standard. Is it about subjective satisfaction, personal taste, aesthetics requiring only good faith dissatisfaction? Or is it about objective satisfaction, functional utility, commercial reasonableness? Would a reasonable person be satisfied? And remember, courts are wary of subjective claims when the party keeps the benefit.
That's a fantastic framework. Clear, sequential, hits all the key points. We've really seen the spectrum today from the absolute, sometimes brutal rigidity of express conditions in cases like Inman and Oppenheimer to the policy-driven flexibility the courts use with ambiguous terms or constructive conditions, like in Rohauer or those pay-when-paid scenarios.
Absolutely. And what really jumps out, I think, is how much power lies in precise drafting. A single word difference, if versus shall, or written versus just notice, can literally determine whether a multi-million-dollar obligation lives or dies. It underscores why careful attention to these clauses is so critical for managing risk.
Definitely. Okay, let's end with a final thought to chew on. We briefly mentioned Taylor v. Caldwell, where Lord Mansfield found that the continued existence of a specific music hall was an implied condition for a contract to rent it. If it burned down, performance was excused. So thinking about today's complex world, how might courts use that same idea of an implied or constructive condition to deal with situations where performance becomes impossible or radically different because, say, a crucial global supplier goes bankrupt unexpectedly, or an entire supply chain collapses due to events totally outside anyone's control? Where does that doctrine stretch? Something for you, the listener, to maybe mull over or explore further.